Okay, guys, we're about to do the Texas court systems, and we're going to fill in this chart. If you have your red packet, we have a chart on the very back page that deals with the Texas court system. This has probably been huge for exam 1. It's also been huge for finals 1 semester. Only chapter 3 was on the final, either misclick or whatever, and there were, I think, 60 plus questions were from this chart that we're about to fill out on the final. Now, that was a one-time thing, hadn't happened since, and I think it was a mistake. But anyway, we're going to fill in this chart. For the 5 phases of litigation, you should have 2 pages on the 5 phases of litigation. I'm not going to go over those right away. If I have time to do another video on like a Wednesday or something like that, I want to get everything done by Tuesday. And then if I can do some little short videos on all the little blurbs from the smaller stuff, I may do like a 15, 20-minute video. But for chapter 6, we're only going to talk about the court system and how it compares favorably to the federal system on this chart. And then we'll go over a few blurbs at the end on dealing with the federal system. And then I'm going to let you read over the rest of chapter 3 on your own. And like I said, maybe I'll hit some of the blurbs, at least from the 5 phases and stuff like that. All right, so we'll talk about the difference between trial courts and appellate courts real quick. Trial courts are going to be the first court to hear a dispute. They're going to decide issues of fact and law, whereas the appellate courts are going to be the second courts to hear a dispute or afterwards, and they're going to only hear at issues of law being misapplied or issues of law only. So lower courts, also known as trial courts, fact and law, where the judge and jury determine what is factual and what is not, based upon preponderance of the evidence or reasonable doubt, criminal or civil trial. And then appellate courts only listen to issues of law only that were misapplied, misinterpreted, or misused. All right, we're going to go through each of these things. So if you get to the municipal court on your chart, I'm going to go down the row. I'm going to go fairly quickly. You can, reverse back and stuff like that if you want to read it over. If you've already done this chart because you came for exam 1, you're not going to find out anything different. I don't think we're adding anything. So we'll have all that stuff, and then we will go over some few things after we're done with it. Then we're going to do a compare and contrast the federal court system. So the first one is municipal court. It is a tier 1. Tier 1s and 2s are trial courts. Tier 3s and 4s are appellate courts. This is a tier 1, so it's a trial court. They are appointed, not elected. The terms are going to vary. It depends on the city council and the city and what they want to do. Law license, it varies once again by city council, but the likely answer is no, they do not need a law license. It is created by the city and city ordinance and city councils. The civil max, they usually don't have any. Now, some do. Some have a civil max of, say, 10K, but most municipal courts do not listen to any civil law at all. Okay, they will listen to the smaller criminal, the Class C misdemeanors, the MIPs, PIs, stuff like that. We'll go over traffic cases and stuff like that. Under de novo, you have it, leave it blank. You have no de novo appeals there because it's a tier 1 case. De novo appeals is when it goes from tier 1 to tier 2, so there's not going to be anything there. It is under the election, there is no election. It is done by appointment. Remember, these are the only judges in the state of Texas that are appointed in the state of Texas court system. Federal court system, they're all appointed for the most part, except for certain ones, but they are appointed. But here, in municipal court, they are elected. They are appointed only. It's the only one that's appointed of all the list. All right. For a question dealing with just municipal courts, you're probably going to have something dealing with the additional notes. They mainly do a lot of traffic cases, speeding tickets, stuff like that, parking violations, everything like that. They will do some MIPs, PIs. They will do noise control ordinances, building code and building code violations, leash laws associated to your pets, dogs. If you have a cat and you put on a leash, that's weird, but cats. And then most of the municipal court system does not have incarceration for anything. There's no jail time associated to it. It's usually only fines. Okay? So for additional notes, mainly traffic laws, speeding tickets, traffic violations, parking violations, MIPs, PIs, noise control ordinances, building code violations, leash laws, and then non-incarceration, no jail time, usually just fines. All right, the next court is Justice Court, Justice of the Peace, Justice Court. It is a tier 1. It is elected. 4-year term. Law license, no. It is created by the Texas Constitution. Created by the Texas Constitution. The civil max is 10K, 10,000. They can also listen to small criminals. So they can listen to civil and criminal for the most part. Small criminal, there's de novo, leave it blank because de novo is from tier 1 to tier 2 again. We're still in tier 1 anyway. The elections for justice of the peace is going to be via precincts, which are smaller than districts, smaller than countywide, and stuff like that. Under the additional notes, 1, you must be 18 years old and a registered voter in the United States. So if we're talking about the difference between someone 19 and 18, someone 17 and 18, you have this for the Justice of the Peace Court. They're often the coroner in a lot of the smaller towns, the coroner. They can deal with landlord evictions. And if you're in 209, landlord liens and stuff like that would also probably fall under this as well. Landlord evictions are also called forcible detainers. So if you want to put landlord evictions and then an arrow down under the next row for forcible detainers, that's fine as well. They will do weddings, many of them shotgun in the courthouse itself. They also do MIP PIs. So if you get a question that says, what court do you go to if you're on campus versus off campus? Well, if you're off campus, it's probably going to be municipal court for an MIP PI because you're in the city area, so it'd be municipal court. If you're on campus, it is likely just the peace court or justice court. Okay? There is usually no record for a municipal court or a justice court, usually, not always, but usually there's no record. Therefore, you'll have de novo appeals of these two tier 1 courts. All right, one of the other questions under Justice of the Peace is, Justice of the Peace used to be 2 different courts separated that have now morphed together. It used to be small claims and Justice of the Peace Court. Now they're called justice courts. It was the same judge regardless that did the small claims and the Justice of the Peace Courts. They did the same thing. It was the same judge. However, the Justice of the Peace Court could listen to small criminal as well as civil, whereas small claims would only listen to civil actions up to 10K. Okay? So whenever you were deciding which judge it was, small claims are done under Texas legislature, whereas Justice of the Peace were done under Texas Constitution. So they fall under the jurisdiction of Texas Constitution now that they've morphed together. But if you had the same judge, if they were listening to a civil case, you couldn't tell the difference maybe. But if they were listening to a criminal case, you knew it was Justice of the Peace Court. If it was a small criminal case, Justice of the Peace, but it wasn't going to be small claims. That was civil only. All right. So note that for Justice of the Peace Court or Justice Court. The next one is County Court. This is Tier 2. That is also a trial court. So Tier 1s and Tier 2s are trial courts, also known as the lower courts, listen to issues of fact and law. They are elected. The term is going to be 4 years. Law license, no, you do not need one. They're created by the Texas Constitution. So the only difference between justice and county court so far is one is Tier 1, one is Tier 2. The civil max for both of those is 10,000. So in those first 6 rows, the only major difference is Justice of the Peace is Tier 1, county court is Tier 2. Now, in criminal, you have Justice of the Peace only has small ones, but now county court can listen to higher ones. They have exclusive rights over criminal cases that are Class A and B. Exclusive jurisdiction over Class A and B cases. So if an A or B, Class A or B criminal case comes on the books, it's going to go to a county court. We'll talk about county court law in a little while. It is a de novo appeal, meaning if you want to appeal a Tier 1 decision, since they didn't have a record of it, it goes to another trial court. The only other trial courts we have are Tier 2, so it goes to a county court is an option. De novo appeal is from a Tier 1 appeal to a Tier 2, and county courts can listen to de novo appeals. The election, which is elected 4-year term, is countywide for county courts. Now, under additional notes, they can listen to juvenile cases. They can listen to probate, estate, wills. All appeals go to Tier 3, which is the Court of Appeals, Tier 3. And there's one and only one county court per county. Now, there's like 250 plus counties, So each county has at least one county court, or only has one county court. Only has one. One and only one. So it doesn't matter what court he says. If he's talking about county courts, how many do they have? The answer is one. Doesn't matter what county he picks. All right. The next one is county court of law. This is a tier 2 elected 4-year term, but now you need a law license. Now you need a law license. So the answer is yes. And if you go the rest of that row, the answers to all of those are going to be yes. You are going to need a law license. For the county court of law, it was created by the state legislature. So you want to put legislature there. And the way I teach people mnemonic device to remember, county court of law starts with an L, law starts with an L. So county courts of law require a law license, and they are created by the legislature. So you have the L's that match up. The civil max is 100K. Some actually go to 200K, but for the most part, they go up to 100K with a few going to 200K. They can listen to higher criminal cases. They also have exclusive rights over Class A and Bs as well, because they are just an extension of the county court system. De novo appeals, yes, de novo appeals can go to county court of law as well. So under county court and county court of law, they do listen to a de novo appeal, which is not a true appeal. It just goes from a tier 1 trial court to a tier 2 trial court, and now there'll be a record of it for the future. Elections are going to be countywide as well. Now, under county court of law, you can listen to some family court. Some family court can be in there, so they can listen to some of the juvenile cases, and they can listen to some divorce cases and stuff like that. Certain ones can, not all of them. You must be 25 years old, a citizen of the county and state for a period of 2 years. All appeals go to tier 3 court of appeals. And for county court of law, you can have 0 in each county if you want, or you can have multiple ones. Harris County, Dallas County, the larger counties, Bexar County. All those larger counties could have more than one county court of laws. Okay? Now, the reason why county courts of law exist, for the larger counties where one county court wasn't enough, you can make on additional county courts as per the state legislature. So that's why they are created by the Texas legislature, to basically reduce the overload in the county court system. You do not have to have any in a county court, or in a county. You only have to have the county court. But if you have more than one, you can have more than one. So for county courts of law, how many can you have? From 0 to, I guess, technically an infinite amount. You don't have to have one, at least one. You need one for county court, 0 to an infinite amount for county court of law. Okay? The next thing is district court. District court is also tier 2. And if you're going to guess on any question, district court is probably the way to go, especially if it's a trial court situation. They are elected to 4-year terms. They require a law license. They were originally under the Constitution, Texas Constitution, but now are under the state legislature's jurisdiction. So which of the following were originally under the Constitution of the Texas government? County court and district court were originally Constitution. You can even throw in justice court if you want. Which are now under the jurisdiction of this Texas legislature. That would be county court of law. They've always been, and now district courts as well. The civil max is unlimited. To anything over 100,000, or in some of them 200,000, have to go to district court. So any multi-million-dollar civil dispute between maybe a company and an individual or 2 individuals that's over 100,000, or in some cases 200,000, must go to district court. There's no other option for the first court. It's got to be it. They can listen to any criminal case. They are going to have exclusive ability to listen to any felonies. So if you get a felony case, the first court that can hear that dispute is going to be district court. You bypass all the first 4 that we did, because the felonies originate in a trial court that is a district court. The election is going to be in the district itself, and that could include multiple counties. Okay? Under additional notes for district court, most family law comes here. Divorce cases and most family and children law come here, although some county courts of law can listen to it as well. You must be 25 years old, citizen of the county and state as well. All Texas statewide election issues come into play, go straight to the district court. 2/3 of the cases are going to be civil, 1/3 are going to be typically criminal. And if it is a death penalty case, it skips Court of Appeals and goes straight to the Court of Criminal Appeals. But otherwise, all appeals from district court go to Tier 3 or Court of Appeals, with the exception of death penalty cases that would go to the Court of Criminal Appeals. All right. I don't think I've already updated this chart for next semester, but if you want to put a big thick line between district court and Court of Appeals, all the ones on the left are trial courts, Tier 1s, Tier 2s, fact and law. All the ones between after that thick line that you made, Court of Appeals, these are going to be appellate courts or higher courts. Listen to law only. Court of Appeal, Tier 3, also known as First Appellate, they are elected to 6-year terms. They must have a law license. They're created by Texas Constitution. All the rest of them are created by Texas Constitution. In order to listen to a dispute at an appeal, there must be more than $100, just a C note, $100, more than $100. If it's under that, it doesn't apply. You have to go with whatever the decision was made before. Criminal, they can listen to all of them. They can even listen to felonies as well, as long as it's not a death penalty case. Death penalty case would skip it. Everything else goes, the appeal goes to the Court of Appeals. It is a de novo appeal? No, it is not de novo appeal. And I think I said no. I want to make sure for district court, they do not listen to de novo appeals. So they're the only trial court that is not eligible to listen to de novo appeals. Court of Appeals do not listen to de novo appeals because it's an actual true appellate court. So it's not a sort of appeal, it's a true appeal. The election is going to be based upon the counties that it serves, so it's not a statewide election. You must be 35 years old, 10 years of the law. Almost all Tier 2 appeals go here. There are 14 of them, all in major metropolitan areas, with the exception of Eastland. Eastland is not a major metropolitan area, everything else is. And I believe in one page of your study guide, it has these listed. I'm trying to find, I thought it was on here. I'll have to find it, but there was a listing of all of them. Okay. Anyway, Court of Criminal Appeals. This is a Tier 4, also known as Second Appellate. They are elected to 6-year terms. They must have a law license created by the Texas Constitution. Civil max is none. They do not listen to any civil matters. Which is the only court that will not listen to civil matters? Court of Criminal Appeals will not listen to any civil matters. Everything else can listen to civil. Well, municipal courts, only some of them can, but the rest of them can all listen to civil matters. Okay? Civil and some criminal as well. Okay? Under Court of Criminal Appeals, criminals, yes, they are the highest court for criminal action in the state of Texas before you go to the Texas Supreme Court. It is not a de novo appeal. It is a true appeal, and you're going to be elected in a statewide partisan, i.e. voting Republican Democrat election. All right? Now, I made an example of when we did this chart the first time. The first 3 or 4 of these are going to be the exact same for Supreme Court, so you can just put an arrow by it. Okay? Appeals go to the federal court system, i.e. the Supreme Court. All cases are heard en banc, meaning all at the level listen to the dispute, and that would be 9, so if you want to put 9 in parentheses there. The Court of Criminal Appeals is located in Austin, and you have to have 35 years plus 10 years of law experience. So and that applies to the Supreme Court as well. Those are all the same, so you put arrows over to the Supreme Court. So for any appellate court we have in the state of Texas at the state level, you must be 35 years old, 10 years of law experience, you must have a law license, and you're going to be elected to a 6-year term. Now, the difference is in a court of appeals, it's only for the counties you serve because there's 14 different ones in major metropolitan areas. Whereas the Court of Criminal Appeals and the Supreme Court is a statewide election. All right. Other things that you want to note is it only listens to criminal and is the highest level of criminal appeal in the state of Texas before you go to the Supreme Court of the United States. And death penalty automatically go here and bypass Tier 3 or Court of Appeals. All right. For the Supreme Court, the answers for the material, Tier 4, also known as Second Appellate. Elected to a 6-year term. Law license, yes. Created by Texas Constitution. Must have more than $100, must be more than a C note once again. They do not listen to any criminal appeals. A lot of people get this confused, thinking the Texas Supreme Court is the highest law in the land. It is for civil jurisdiction in the state of Texas, but not for criminal jurisdiction. They do not listen to de novo appeals because it is a true appeal once again. Election is a statewide election and a 6-year staggered term bipartisan election. Under the additional notes, once again, appeal to the federal court system, U.S. Supreme Court, heard en banc, 9 justices, located in Austin, 35 years plus 10 years of law experience. And the other ones that are specific to the Supreme Court, only civil, and it's the highest civil in Texas for appeals. They listen to issues of state bar qualifications and then also civil procedures. Now, what he does on these storylines is if he gives you a storyline, he'll say which court has jurisdiction. And jurisdiction just simply means which court can listen to the dispute. Well, some of them could have multiple, like if it's a divorce case, district court's going to be your main answer, but some county courts of law could listen to divorce case, family law as well. So those are both multiple choice options, A and B, but not C, C and A, but not B. If he says most divorce cases go to this court, then the answer is probably going to be only district court. Which of the following courts were originally created through the Texas Constitution? Then you'd have county court, district court, any of the appeals courts and stuff like that. Which ones are currently under the state legislature? That'd be county court of law, district court now. Okay? If he asks you, where would you go for a felony? You go to district court. If it's not a death penalty case, you go to tier 3, court of appeals. Then you would go to criminal appeals, tier 4. You wouldn't do Supreme Court because if we're talking about felony, we're talking about criminal matter, not civil. If we're talking about the tort associated to a criminal action, then you would go district court, probably because you're going to go for the unlimited amount. Then you're going to go court of appeals, tier 3, because we don't bypass that one. And then you're going to go Supreme Court before you go to the federal system. So understand that. You go from tier 1 to tier 2, and only 2 of the tier 2s work, county court of law. You go from tier 2 to tier 3 with the exception of a death penalty case. You go from tier 3 to tier 4. Once you go from tier 4, the only thing you do is go to the federal court system and you go to the U.S. Supreme Court. All right. The last thing you need to note is for county courts of law, and district courts in Brazos County, we have 1 county court. All counties have only one and only 1 county court. We have 2 county courts of law in Brazos County. And we have 3 different district courts that go through Brazos County. One that's mainly Brazos County, and then others that enter into Brazos County areas, including other portions like a Wixom Valley, a Curtin, stuff like that. So you have 3 district courts that kind of go over. There's like 350 different district courts in the state of Texas. So if he gives you a number like the 353rd district court, just understand if he gives you that, he may be just asking you a question, where does the next step from there? Okay? You're probably not going to need to know where the 353rd district court is. Just understand the 353rd district court is a district court. So it goes from county court of law, to the Court of Appeals, but it would go from district court to the Court of Appeals as well. Okay? And remember, it wouldn't come from municipal court or justice court if it went to a district court, because they don't listen to de novo appeals as well. All right. You should have this chart filled out. The other thing that we need to do is talk quickly about the difference between the federal court system and the state court system as well. Remember, for tier 1s and tier 2s in the state of Texas, those are our trial courts, lower courts, the first courts to hear the dispute, fact, and law, whereas the tier 3s and the tier 4s are going to be our appellate courts, also known as higher courts, and they're going to decide issues of only law being misapplied as well. Now, the federal court system on page 62 of your study guide talks about Article 3 of the Constitution, deals with creating the United States Supreme Court and any constitutional courts created after that. Constitutional courts like district court, circuit court, Supreme Courts, the judges are going to be appointed by the president as long as they're confirmed by the Senate, not Congress, confirmed by the Senate, and they will serve life terms. So one of the questions that people get is they're elected to life terms so long as they're confirmed by the Senate. No, they're not elected, they're appointed. As long as they're confirmed by Congress, they can serve life terms once they're appointed by the president. No, because they're not confirmed by Congress, they're confirmed by the Senate. So appointed by the president, administrative agency heads are appointed by the president as well, okay? Serve for life as an appointment as long as they are confirmed by the U.S. Senate, not the House or not Congress, okay? Now, the trial courts are called federal district courts. Federal district courts only are in a state. They do not cross over state boundaries. So district courts at the federal level will not cross over from one state to another. Now, a state may have one district court or it can have multiple ones. The larger the population, the more district courts it's going to have. We in Texas have 4 district courts. Now, you have a bunch of different judges at that district court level, but you have one district court. We have the northern, southern, eastern, and western. Waco, Hearne, Austin, El Paso are all in the western. Dallas would be in the northern, I believe. Tyler and all that stuff would be in the eastern. College Station, Bryan College Station is in the Southern District Court of Texas. Southern District Court of Texas would be the federal system, and that's located in Houston, okay? But we have 4 in our state, okay? Northern, Southern, Eastern, Western are our 4. Usually have one judge, although you can have multiple district court judges. Only one judge is going to listen to the dispute, usually a jury of between 6 to 12 people. Okay, the Court of Appeals. The Court of Appeals are numbered 1 through 11. There are 13 total courts of appeals numbered 1 through 11. Each state will be put into one of those. Texas is in the 5th Circuit along with Texas, Louisiana, and Mississippi. So if you ask the question, which states are not a part of the 5th Circuit? Texas, Louisiana, and Mississippi are the ones. The larger, and they can include multiple states, like the Northern Atlantic states have like 9 or 10 in theirs, okay? They're numbered 1 through 11. Puerto Rico is a part with the Northern Atlantic states. That's number 1 circuit court. The most liberal is the one dealing with the Western Seaboard. That would be Washington, Montana, Oregon, California especially. It's so big that it has a courts of appeals, and I think Los Angeles and San Francisco, separate ones, whereas our circuit court is located in New Orleans within our 5th Circuit, okay? So we are numbered 1 through 11. We also have 1 in Washington, D.C., so that'd be the 12th one. And then the 3rd one is going to be for intellectual property, government, international trade, intellectual property, and stuff like that. And if you're in 211, you have all that stuff with global would fall under the international trade would fall under that one as well. Okay, you have multiple judges from circuit to circuit. Most of them are going to listen to it in a 3-judge panel. So it's an appellate court, the federal courts of appeals, i.e. the 13 circuit courts, are going to have multiple judges. Usually a 3-judge panel will listen to a dispute. If all these multiple judges listen to it, it's done en banc. En banc just simply means all the judges at a certain level will listen to the dispute. Okay? So if the appellate court makes a decision, it is only binding upon the courts within its jurisdiction. So the 5th Circuit renders a decision in New Orleans and renders a decision and establishes precedent. And remember, precedent, if we talked about it in chapter 1, precedent is established when a majority opinion of an appellate court is written and published. Well, majority opinion, if you have a 3-judge panel, you're going to have a majority opinion. It's either going to be 3-0 or 2-1 in favor of somebody, correct? It's not going to be 1-1-1. You're going to have a 2-1 or 3-0. So that's a majority opinion. If it is written and published, it will establish precedent. It will only be binding its precedent on courts involved in that 5th Circuit. So if New Orleans renders a decision, whether it's done en banc or in a 3-judge panel, and a majority opinion is written and published, it will establish precedent for Texas, Louisiana, and Mississippi until there's a logical and rational reason for overturning it. And the case associated to that was Hopwood. Hopwood was a reverse discrimination case in which white applicants were denied admission to UT's law school because they were given a quota system for those that were minority candidates. Minorities were given higher bonus points, and although qualified, were not as qualified as the white applicants. The white applicants sued for reverse discrimination and won. So the 5th Circuit rendered a decision saying affirmative action programs such as this were going to be illegal actions in regards to this for point systems for higher level education in law schools and stuff like that. Whereas in the 6th Circuit, Michigan was doing this, the same basic quota system at the undergraduate level. The University of Michigan was found to be legal. So the Fifth Circuit said it was illegal. Sixth Circuit said it was legal. Okay, there we have a problem with diverging circuit courts. All right. Once appealed, if it gets appealed, it goes to the Supreme Court. The Supreme Court is a court of last resort for all state courts and/or the federal court system. 1 chief, 8 associate justices. All cases are heard by all 9, so it's done en banc. They are going to basically listen to appeals that are granted writ of certiorari under the rule of force. Now, there are some rare original court jurisdiction where they can listen to a case rarely, but originally they can be the original court, so they could listen to it as a trial court system, but that's very rare. Usually it's going to be because of an appeal by the losing party and they grant writ of certiorari. Writ of certiorari is under the Supreme Court Selections Act, the right to set jurisdiction other than constitutional jurisdiction. It basically says, here's how we're going to do it. And they call it the rule of force. The rule of force says if at least 4 of the 9 justices by secret ballot agree to listen to the dispute, they will grant writ. Now, of all the thousands and thousands of cases that are appealed to the U.S. Supreme Court, only 100, 150 cases are granted writ. About 1 to 2% of all the cases get writ granted to them. If writ is granted to them, then that means the rule of force, not a majority, but 4 of the 9, that's not a majority, by secret ballot agreed to listen to the dispute, and now all 9 will listen to it after writ has been granted. Okay? They will usually do it on state courts misreading a federal law, state courts in conflict with the Supreme Court, issues that have not been previously decided by the federal courts, or if circuit courts are diverging, meaning the Fifth Circuit's rendering one decision, Sixth Circuit, let's take a case, render a decision, now it applies to all the states. Because once the Supreme Court renders a decision, it applies to all the circuit courts and all the district courts below it, which would be all of them, okay? So understand this, the Supreme Court does not have to take cases except for original constitutional jurisdiction. So if it's rare, it will happen, but for the most part, it will be done by a grant of writ by the losing party if the rule of force applies. Secret ballot on that once again. If it is not granted writ, i.e. 99% of the cases are not granted writ, the decision stands and will serve as precedent within the lower courts, i.e. if the Fifth Circuit renders a decision, the losing party appeals to the Supreme Court, it is denied, no writ is granted, then it serves as precedent for future court rulings in the Fifth Circuit, Texas, Louisiana, and Mississippi. All right? So note that is on page 63 of your study guide. We've already talked about the selection of judges. We already talked about jurisdiction. So we're going to talk a little bit about jurisdiction here on page 65. We'll end the video at the end of 65 real quick. And then if I do I might do a secondary video where I talk about little blurbs. But I think from 65 on in chapter 3, if you read those 2 pages on 5 phases of litigation, you should be pretty good there as well. All right. Under jurisdiction. Jurisdiction is the power of a court to hear and listen to a certain type of dispute. So if he asks you in the state court system, which court has jurisdiction, then you use that chart to figure all those answers out that we did on the state court system. However, for the power of a court to hear and decide a certain type of case, they must have jurisdiction. And in order to get jurisdiction, you must have both subject matter and territorial. Now, subject matter is just state versus federal. Federal courts can only listen to certain type of disputes. And it goes it's a little weird, it's a little backwards from common sense. You would think mainly that federal courts could listen to federal and state laws within their area, and then the state courts can only listen to state law. It's opposite of that. It is states can listen to state and federal law, whereas federal courts can only listen to issues of federal law only. The exception being diversity of citizenship. So a federal court can only listen to federal statutory law created by Congress, federal treaties, federal administrative agency, constitutional issues with the U.S. Constitution, or if we have a diversity of citizenship. This is also called the removal doctrine, and diversity of citizenship says if 2 or more parties are from separate states, say there's a lawsuit, and 2 or more parties are from separate states, and the amount exceeds $75,000, the federal court is an option, not a requirement, and that's been the difference between answers A and B and C and stuff like that, and people put the requirement, it's not required. 2 different states completely, no link, and $75,000 or more, they could possibly go to federal court and not have to go to state court. Okay? Now, when it comes to states, so states can listen to more. They can listen to state and federal. Federal courts can listen to only federal, with the exception of the removal doctrine and diversity of citizenship. Now, territorial jurisdiction is basically the power of the court to require a litigant to physically come to court. You can always sue a defendant in their home state. So if you have 2 people from separate states and the amount exceeds $75,000 or more, well, then you can go to a bunch of different courts. One, you can go to county court of law or district court in Texas, because since it's got to be more than 75,000, it's only county court of law or district court, and maybe even some county courts of law can do it depending on how much it is. Or you could go to federal court if you so choose, but it's got to be over 75,000. So in terms of if it's 85,000, county court of law, district court at the state level, or federal district courts you could do as well because of diversity of citizenship. Now, if they're both from Texas, it doesn't work. You would have to go to county court of law or district court, and you could choose between those, unless it's a felony versus a class A or B. Okay, but you can always sue a defendant in their home state. So say someone from Texas is in a lawsuit with someone from Oklahoma, and they want to sue. If they can get that person to come back to Texas, they can sue them in whatever court in Texas system has jurisdiction using our chart. Okay? They can get that jurisdiction through in personam, i.e. make them physically come to court with a summons to appear. They can serve the defendant with papers. You've been served. Now they have to come, the power of the court, to order the defendant to show up at the specific court, whichever court you decide to go, county court of law, county court, district court, whichever one applies. Okay? In rem jurisdiction is where the court has territorial jurisdiction because a property at the central aspect of the lawsuit is in a given state. If it's in the state of Texas, say it's in Brazos County would have jurisdiction. That can be county court of law, that can be district court, that can be even county court. Okay? Quasi in rem is property is central to the lawsuit, but not the main subject matter. And since that is historically abused, if states wanted to have it in their state, they would abuse it. It's very rarely and has a close scrutiny on whether or not quasi in rem can even be used. Rare historical abuse is the reason why it is rare. I would note that. So let's say we have a case of $100,000. You can go to county court of law. You can go to district court. If they're from separate states and it's more than 35,000, you can go to federal court. Or if you can't get them in personam or in rem to bring them back to Texas to do county court of law or district court, you can always go to their home state. So if it's someone in Oklahoma, you can always go to Oklahoma State Court and sue the defendant in their home state. All right? Okay, and then venue is which court with jurisdiction, although there's multiple ones, would be the venue would be county court of law or district court if it's both of those could apply. You pick out which one, okay? You can serve the defendant in many different ways, usually through registered mail or stuff like that, but that would, we don't allow forum shopping in the state of Texas because we have forum non-convenience rules. Okay, the next 5 or 6 pages in your study guide are the 5 phases of litigation. You should have a page in the red packet dealing with 5 phases of litigation. Read over that. Everything bolded has been on previous exams before, but I don't think you need a video for this one. If I do have time after I get chapter 4 done, I will probably come back and do all the little areas that I missed, a quick like 15-minute boom, boom, boom thing. This will be in there. All right. That's it for chapter 3. We will start with types of contracts on the next video.